Welcome. My name is Mike Hintze. I am the chair of this session on behalf of the University of Washington School of Law, where I teach privacy law. I also wear another hat when I'm not teaching. I'm also the Chief Privacy Counsel at Microsoft. I have the pleasure today of chairing what I think will be a fascinating discussion that will elicit a wide range of views among our panelists. Today we're talking about what role the market forces can play in protecting individual privacy. This is an area in which we do see some positive signs that the market forces can lead to some improvements in privacy practices. We see companies trying to position privacy as a competitive advantage, positioning their privacy practices as superior to those of their competitors. We see new apps and services arising that are being widely adopted that purport, at least, to provide stronger security or privacy protections, and then there's been a lot of take-up among consumers of those kinds of offerings. And we see consumers purporting to demand privacy, and we're certainly seeing enterprise customers demanding very strong privacy and data security practices in contractual negotiations. But at the same time, people have expressed some skepticism that the market forces are really up to providing meaningful privacy, or at least that they can't do it on their own. And some would argue that because privacy is a fundamental human right, we should not be relying on the market to provide that. So today our panel will be discussing those issues about how market forces can interact with privacy and help provide privacy or not. When might market forces be most effective, and when might they fall short? And how might that question be addressed differently across different parts of the world? We have an excellent panel of experts on the topic today, which I will introduce briefly and then hand over to our moderator. To my right is Hanna Draper, our moderator. She is a program manager with the Open Society Foundation's Information Program, and works on issues affecting civil liberties, such as privacy and freedom of expression in the digital environment. She joined the Open Society Foundation in 2013 and is based in London. Prior to joining the Open Society Foundations, Hanna worked as an advisor to Anne Cavoukian, the Information and Privacy Commissioner of Ontario, Canada, and her personal research interests focus on the intersections of technology, law, and equality. On the other side in the middle there, we have Tanguy van Overstraeten. Tanguy heads Linklaters' global data protection and privacy practice, as well as the technology, media, and telecommunications practice in the Belgium office. He also chairs the firm's Internal Information Systems Board. With over 25 years of experience as a lawyer, Tanguy's developed comprehensive practice in the field of information technology, with a focus on data protection projects, electronic communications, IT procurement, and outsourcing. Tanguy is a member of the Digital Economy Committee of the American Chamber of Commerce in the EU and co-chair of the IAPP KnowledgeNet initiative in Brussels. And he lectures on data protection at the University of Brussels as well. On the far left, we have, that's not politically, it's just where you happen to be sitting. We have Tal Zarsky. Tal is a professor at the University of Haifa, Faculty of Law in Israel. His research focuses on information privacy, internet policy, social networks, telecommunications law, online commerce, reputation, and trust. He also teaches and studies contract and property law and theory. He's written and presented his work on these issues in a variety of forums in the US, Europe, and Israel, and he's advised various Israeli regulators, legislators, and commercial entities on related matters. Tal was a fellow at the Information Society Project at Yale Law School and a Global Hauser Fellow at NYU Law School, and completed his doctorate dissertation, which focused on data mining in the Internet Society at the Columbia University School of Law. Over here to my left is Carolyne Vande Vorst. Carolyne started her career as a legal consultant within the corporate and commercial law team of PricewaterhouseCoopers in Belgium. And in October 2013, her team spun off and created Law Square, an independent law firm located close to Brussels here. Her practice focuses on corporate and commercial law, including IP, consumer relations, and M&A. She specialized in legal aspects of technology with a particular expertise in data protection and privacy. She's participated in Article 29 Working Party consultations and is currently an external advisor to the cabinet of Belgian State Secretary Bert Tommeling, did I pronounce that right, for policy matters related to privacy. And over here on my right, again, not a political representation, we have Renata Avila, who is a human rights lawyer from Guatemala. She's worked as one of the lawyers representing Nobel Peace Prize laureate Rigoberta Menchú Tum in Guatemala in the genocide case before the Spanish courts. Renata has been involved in internet and human rights research since 2009, and she actively collaborated in drafting the launch of the Madrid Declaration. She joined Sir Tim Berners-Lee as the lead of the Web We Want campaign at the Web Foundation, dedicated to preserving and upholding human rights, especially the right to communicate in private and to responding to threats to the future of the web. She also currently serves as a member of the Creative Commons Board, the Creative Commons Board of Directors, as well as the Courage Foundation Advisory Board. So with that, I will turn it over to our first panelist, Tanguy. Take it away.
Thank you very much, Mike. Well, as you can imagine, as a lawyer, I'm not going to look at the multiple facets of the topic, but really focus on, let's say, the legal aspect of it. And I would like to start with, I believe, a non-controversial statement is that new technology will always go faster than legislation. And that, in fact, if you want to drive innovation in a marketplace, you should have a system, a legal system, that do not block innovation. Of course, to some extent, it is necessary, of course, to have boundaries, but these boundaries should not be blocking the innovation, should not be blocking the development of new technologies. Based on that, I would like to cover three aspects. And of course, all of them are subject to debate afterwards. The first one is that it is important for enterprises, for the private sector, and I will focus my attention on the private sector, to have clear and efficient rules. And to achieve that, I think it is important to have general principles in the legislation, to have guidance, and to make sure that these general principles apply in all cases. So to have a system which is technology neutral, sector neutral. And that besides that, with these guidance, the companies, the sector can develop, it could be also associations, of course, of companies, can develop a set of self-regulatory rules that they follow to make sure that they are compliant. If you look back, the way, and I'm focusing my attention now on the European side, if you look back to General Data Protection Regulation, the draft, I believe it has tried to reach that goal because it reproduces to a large extent the principles of the Directive 95/46, which to some extent creates this environment of general principles. And in addition to that, as you may have read already, the latest release, the latest text, which has been released last month, shows numerous, in fact, provisions in relation to the development of code of conducts, of certification process, so all self-regulatory environment. Then I think the next step, which needs to be explored, is how does that develop? Because one of the, I believe, issues that I have when I read the text, when I read the proposal, which is now on the table at the level of the Council, is that the way codes of conduct will have to be adopted if this regime is adopted as it is. They will need to go through a process which I believe is quite burdensome and which will also be subject to monitoring. Monitoring is fine, I believe, as long as it is done by those who have implemented the rules. I am less convinced that there should be an extra layer of review of adoption process, etc. Why? Well, because in fact, when you look back a bit earlier than that, let's say before the release of the first draft in January 2012, the purpose, I think, was really to investigate a way to have more accountability, to create more accountability among the key players, the stakeholders. And one way to achieve that was to move from an ex-ante administratively burdensome way of doing things to a more ex post with more enforcement, more sanction. And I think this is really the frame that should be put in place and therefore supplemented by self-regulatory assessments and self-regulatory rules by the market players. Unfortunately, today, when we read the text, it is not the case. I think we have a combination of ex post, but also a lot of ex ante. So we have, I would say, if I want to be provocative, the bad sides of both worlds. We have a burdensome coverage that needs to be followed by companies, that will need to be followed by companies, while in fact they may be severely hit by the sanctions. I would prefer to have a system by which we increase the responsibility of, in the right sense of the term, of the private sector. We make sure that the private sector has the right guidance, the right principle to develop a self-regulatory environment that they then follow. And of course, if this does not lead to the right compliance, then they could be hit by the ex post review. Let me add a third layer on this, which is that we now live in a global world. We have no choice, but we are faced by the fact that our data is flying from one place to the other. We all use, to some extent, cloud services, and we, at a given time, we do not know where our data will be, or at least we have less grasp on the data that we have than when we keep it with ourselves. Why do I say that? Because I also believe that the current environment that the European institutions are developing should be such that it is still efficient, it is still, let's say, accessible and realistic to apply, so that in fact this would become the guidance for the world. If you look at the number of countries, more than 100 now, that have adopted a legislation on data protection, most of them, or let's say a very large amount of them, large number of them, have adopted rules that are very much mirroring what the directive is saying. I would very much like to have a regulation that becomes the standard of the future, the standard of the world. If we can achieve that, I think we will have done a major step to make sure that there is harmony in the rules as they are applied from one country to the other, from one continent to the other. So let me conclude and say simply that, in my view, there should be a combination of the EU-based principle that there should be no, there should be neutrality in terms of technology, in terms of sector, and a more ex-post approach, which I think is more the case in the US. So that is just my first words, and of course open to debate.
Tanguy, thank you for that. I just wanted to ask you at this time if you wanted to elaborate perhaps on some successful approaches to self-regulation that might serve as useful examples for us later in our discussion.
Sure, thank you. Well, the first that comes to mind, I believe, is the development of the standard clauses. You may wonder, yes, this is work of the European Commission, indeed, but you all know, I believe, that there are two sets of standard clauses when you talk about a transfer of data from a data controller to a data controller. So an exporting company being a data controller, exporting outside of the European Union to an importing company which is also acting as a data controller. In that case, you certainly know that the second set of rules has been developed by organizations like the ICC, the International Chamber of Commerce, and as a result, it's more accessible, it's more business friendly, and I can tell you that among my clients, most of them, when they adopt the standard clauses, will use those rather than the ones that had been developed initially and that were too burdensome for businesses. So that's an example of that. I would also like to give another example, which is a bit more exotic, which goes beyond the border of the European Union, which is what has been developed in Japan. I don't know if you're familiar with that, but in Japan, they have a system which is called Privacy Mark, which is already quite elaborated system of certification. And I was reading on the website, In fact, by March 31st, 2014, so that's the end of their fiscal year in Japan last year, they had no less than 17,905 companies having adopted Privacy Mark, which I believe, you can question that, and I'm open again to debate, which I believe shows that certification can work and can be sustainable even outside the European Union.
Thank you very much for that. Now I'd like to pass the floor to Tal for your opening statement.
Thank you very much. I want to thank CPDP and the University of Washington for putting together this very interesting panel. I will open with 4 points that are based on prior work of mine and other scholars as well, and they all come from the intersection between global law, markets, and innovation. In the background, we have the underlying question as to can the market achieve an acceptable outcome when people have a problem signaling their proper, real privacy preferences. On the other hand, if we're more too aggressive in trying to figure out what people's preferences are, we might fall into paternalism or even more difficult issues. So having that in mind, I'll introduce 4 points. The first point I think is quite obvious, but it's worth mentioning, that the current ecosystem of information is leading to the outcome that the majority of systems, products, services out there are premised on a business model that you collect personal information and provide said service or process without payment. On purpose, I didn't say the word free. Now, why is that? That is because the economics of setting up such a system are extremely efficient. You don't have to deal with money. You don't have to cater to different costs that other models require. And also, there's a great deal you could do with the personal information you collect. So any other system that will provide privacy must overcome the benefits that this very aggressive alternative provides. So this is the undermining premise that we see why you have such great success of firms that are unrespecting or disrespecting privacy of individuals. Okay, so that's obvious point 1. Now, the next point is a bit trickier, and the previous panelist noted that we live in a global environment. Now, what I want to point out is that once you have regulatory arbitrage in play, which means that some regimes are less protective of privacy than others, based on point number 1, we will see innovation and new business models flocking to this less protective regime. And when I say flocking, that means that people move to that regime, data moves to that regime, innovation moves to that regime, and that is where those products will be developed for this market. So to some extent, it's possible that people from the EU are moving their startups to the less restrictive privacy regime, and then the models are developed, and then people in a protective regime, they say, oh, that's great stuff, we want to use that also. And that comes to the ex post process mentioned before, but it's a very different process because people already see this product, they're using the product, and at times the laws are bended, amended, changed to allow such products to become introduced. Okay, now this dynamic does not work the other way around. So here I'm explaining why once you have this arbitrage, not only we will see development of some processes that are not respective of privacy, but that these latter processes will come to dominate the market globally, even in regimes that are more protective of it. Okay, so the third point of my 4 would be what can be done to change. So there are a few options. One option was exactly what the previous panelists noted, to have a global strict privacy regime, and then such arbitrage will not unfold. The chance of that happening is probably quite low. And there's another normative discussion that I'm not going to get into if that's really a good idea. A second solution would be that we'll have strong public opinion which will say we're not willing to accept these products that give us great services without paying for them but collecting personal information. So if people will shy away from using them, so the dynamic I mentioned will not unfold. Now, will that happen in the near future? I have no idea. We do see changes that people are becoming more sensitive to breaches of security, as well as the option of collecting their personal information by government. But do we see people more sensitive to the collection of information by specific firms, the understanding of the detriments that come with that, and on the end of the day, even though they're not paying for the service, they're paying for it through another way? I don't know. And perhaps for the solution, if we'll get to talking about solutions, will be a moving public opinion to understand that point. Okay, my last point, I don't know how I'm doing on time, is considering the option that the government should be more aggressive in signaling to the market what kinds of privacy-enhancing innovation we will be interested in. There are various ways in which government could signal what kind of innovation it's interested in. I would at least argue that in this context, and this is something that was discussed in a panel yesterday, the linkage between environmental law and privacy law could be of relevance here. So a few decades ago, there was discussion as to, in the US, how we could enhance various forms of innovation that promotes environmental protection. And famous scholars, Richard Stewart and Bruce Ackerman and Dennis Hirsch in the last few years, pointed out that directly requiring innovation is not a good idea. Even though it might promote specific forms of innovation, government has a very poor track record in identifying what forms of innovation will be successful. If you adopt said policy, you will be sacrificing other forms of innovation various firms might be involved with, but will, again, opt not to engage with because of the governmental mandate. So this form of aggressive, direct government signaling as to what form of privacy-enhancing innovation we would be interested in is probably not the best idea, but there are possibly less aggressive options that we could talk about in the Q&A. I guess time is up, right? So thank you very much.
Thank you. So I kind of want to pick up on your last point. I'll maybe ask you a preliminary question that can maybe stimulate the Q&A later. But what do you think is the way forward then? What sorts of innovations, what steps do you think could be taken to change the public opinion? What do you think, where's the hope? Where does the hope lie?
Right, so this actually is tied into a discussion that was part of a previous panel, which talked about coming up with methods where you could enhance secondary information flows as to acceptable and unacceptable privacy behaviors, right? So this might be the way to go to strengthen the public's understanding truly what firms are doing with their information and how that links to the presentations they're making as to what they say they will be doing. Government can play a role with it, NGOs can, and this is a less direct form of interaction, but I believe that we saw in many other instances, flows of secondary information online were able to create changes, move people to action, so this might be a plausible move in this aspect as well.
Thanks, and I'll leave that there for now and pass the microphone over to Carolyne.
Thank you, Hanna. Good afternoon, everyone. For my opening statement, I thought of taking a bit of a step back and look at it from a pragmatic point of view. The question is, can market forces be enough to have privacy in the world? Well, what are those market forces? What do we see in the market? Well, you have 4 types of market forces, if I can say it so bluntly. For me, you have those that are really wanting to be compliant and that are making their branding out of that and distinguishing themselves, like Mike said earlier. So remember also the corporate social responsibility, branding, and companies that are really focusing on that. Secondly, you have those that are in a breach mode. They cannot afford to not look at privacy because they may risk a lot of damages from a branding point of view, from a reputational point of view. On the third aspect, well, you have those that are not even aware of what privacy is and how they are impacted. And in the fourth category that I see in the market is those that are aware of privacy. They know that, well, probably they will fall under regulation, but then comes the everybody knows question, the so what question. And as long as we don't convince those two last categories of the importance of privacy and the impact of privacy, I think market forces will not be enough. And that's where regulation comes in. Because regulation is definitely not the best answer, but it's at least an answer that gives the minimal standards or that gives a point of view of where we need to go to. What are the enablers for me to convince those two last categories? Well, first of all, as Tanguy already said, it's a framework, a legal framework, but that is simple, principle-based, and future-proof. There's no point in making a regulation that covers all scenarios, because who knows where technology will stand in 10 years of time. Secondly, knowledge sharing platforms. You have the conferences like this one, very interesting. You have the IPP, for example. But what in practice, what for companies, when they have a regulation saying privacy by design, okay, they want to comply, but what does it mean in practice? How do you start a privacy by design project? What does this mean? Do I need to talk to my IT people? Do I need to talk to my HR people? What does this mean in practice? So there's a need for information on that. Also, I think there's the fact that you need to make companies aware. The awareness campaigns are still very important because you have those companies that don't realize that they fall under the regulation or fall under privacy. They don't even realize what private information is or what private data is. What are the missing links for me? That was also mentioned before, I think. It's when you talk about market forces, about companies, about commercial companies in the private sector in particular, you will only get them in action if they have a business case, if the benefit exceeds the risk. That answers the so what question. So the business case needs to be more developed. If we approach privacy from a risk-based perspective, I'm afraid that will not work. We need to show what the benefits are, what the opportunities are with data. And even when you're compliant, that you can see the data. For example, data control, bottom-up data control. What data do you have? Where is it located? Who has access? Once you have that information, you understand also the opportunities that it has, but it's also easier to be compliant. I think those are the key points that I wanted to make as an opening statement.
Thanks, Carolyne. Just as a quick follow-up question, I was wondering, could you tell us or give us some examples of how you see the importance of privacy sometimes being misunderstood or misperceived by the market?
For example, the question that I see a lot in practice is the B2B, B2C question. A lot of companies are asking me whether or not they fall under legislation because their activities are just restricted to B2B, business to business. So they're not offering services or producing products for consumers. But in fact, still, when you have very simple example, you have a website, you have a contact form. You have a business, which is maybe a supply manager, that is contacting you for more information about your products. He's filling in the contact form. You immediately have a collection of personal data. So that's an issue that I see a lot being misperceived as well.
Thank you for that. And now I'll pass the microphone over to Renata.
Well, I will try to make the conversation a little bit more human, because I feel like that we talk about regulation. We are very, very like kind of centered in a EU-US context of regulations in countries where the rule of law actually works and where there's proper authorities in place and in an ideal. But what's going on right now is that EU companies, US companies, and some Asian companies are polluting the world in a sense that I really like your analogy of environmental law and this that we are discussing, because what I see is the market has driven the production of devices and services in a model that is designed to break by design, break make kind of commodify the data of individuals and break the private sphere that was preserved before. We have cameras everywhere, we have tracking devices everywhere, and that's what the market is pushing and selling. And it's a market that is concentrated in the global north, that is spread all over the place, and that is, it might affect in ways that we cannot even foresee different countries. If you think the impact, for example, of tracking technologies and profiling in Europe, where there's a proper human rights frame, will be very different if you consider the effect of those technologies in a country where genocide might happen, or where the situation can go really, really, really wrong. And what I haven't seen is a push in a different direction. I mean, while there's lots of money invested and lots of funds and lots of incentives for internet startups, for small businesses, and for companies to develop even further this model of business that is based on data collection, data retention, disruption of this private sphere in the houses, in the schools, in the streets, and so on. I haven't seen, because of my work, I have followed closely all the developments of design, a different type of design and a different type of companies. And there's very little funding actually willing to fund privacy innovation and a different way to design our future, a different way to conceive even our public space. And that's market, but that also there's a big actor that plays a role here, is the state. It is on the interest of the states to promote this kind of, this kind of technologies. And very few nations have seen the different perspective. The very few countries have actually said that they want more private citizens, because the more private space they equate private spaces to spaces they cannot control. And spaces that they cannot control are, the narrative is that if you don't have surveillance, if you don't have this invasive situation where you track and control everything, then your citizens are insecure, and then your public policy is not well designed because you're not collecting enough data. Then your marketing will not be successful. There is this data hunger and this knowing everything that everyone does, like the big things that are driving the market forces. And this new thing that, for example, if I go to what's going on with internet.org and these free services, free internet services, how even everything that you do can be, companies can make a profit of what the poor in the global south do every day, this false idea of free services and of getting the poor connected. So I think that it can be the only change that we can get out from the market is if we change this narrative and actually people start realizing, as they start realizing in the early days of pollution, what this contaminated environment when no one has even the right to have a private conversation, or where we start losing things that are in the public interest, like the right to communicate in private with my business partners, the right to communicate in private with my client if I'm a lawyer, the right to organize myself and have a union, for example, or these kind of things. If we do not communicate well to the people that there's a real harm in having this weak and even weaker and weaker society that is going just in the wrong direction, if we don't create that demand, I don't see any solution in the market. And I don't see any solution in self-regulation, because in countries like mine, you can barely apply regulation, and you don't have leverage in the industry. I mean, the majority of the world has no leverage in this industry that's heading in this direction. And it is hard to shift the model, and it's hard to go back to a more autonomous way of consumption and production. And I mean, there's nothing that you can produce locally and consume locally and design in a better way. Or maybe there is, or maybe there is the solution. Maybe if a country or if a group of companies decide to test some models in just the opposite direction, maybe it's there, but I'm very, very pessimistic, like really, on this. And yeah.
Thanks for that, Renata. Just to clarify for the discussion moving forward, could you maybe give a couple concrete examples of who you see those benefiting from the status quo regimes and those who are being harmed by it?
I will see, like, there's a divide between old businesses and new businesses. I think that new companies from certain countries saw the comparative advantage of having this collect everything, know everything model of the future, and they are benefiting the most. And actually in the private sector even, those old businesses and all institutions are suffering the greatest harm from it. I mean, you see cases of industrial espionage, you see cases of serious information compromised and known by other actors. Something that is very interesting as well is that while people are spending like lots of money in and the market is like going in the direction of more and more data collection and retention, there's very little investment in security, and there's very little investment in the commons infrastructure, and I see that very problematic. And yeah, so basically that's what I see. So.
Thank you. I've prepared some questions to keep the conversation going, some of which have already been touched on by some of the panelists. But at this time, I just wanted to ask if there's currently any questions from the audience. I believe there's a microphone in that hallway, unless you want to yell.
Donald kindly mentioned that we have this business model of free services, and then you pay via your personal data. But I think we are long past that point, because nowadays you see you have to both pay for the service and you give away your personal data. And so, for example, you have a couple of cases in the US with telecommunication operators who basically basically sell your browsing behaviors to advertising companies. There were a couple of cases with Verizon and so on. Or another example from a consumer side, if you buy a sports watch today, you can barely configure the watch without having a cloud account. And so I'm wondering how that impacts your assessment about these economical models.
Tal, did you want to respond to that?
This is a very interesting point. It might even further unfold if we see cell phone operators trying to capitalize on the access to the individual through developing apps. Still, I haven't thought about this point, but one of the benefits of the internet actually is that it allows new firms to come into play where they weren't previously in privy in a billing relationship, such as the operators, or don't have a physical presence such as the watch you mentioned. And many of these companies also have vast benefits, positive externalities that unfold when their businesses come into play. And that's what makes this issue difficult for me to establish what I think about. So if the phone company should be able to tag along on its bill and capitalize on its personal information, or the other examples you mentioned, it might be easier to come down on them. Their presence is in one place. There's a physical presence, but the other instances where all the products are virtual, the workers shift around, the data shifts around, the product shifts around, that has specific advantages and disadvantages, which make the conversation more interesting to me, but that's a very valid point.
Do any of the other panelists have any other responses to that question?
I have a quick. I think that the position of consumers right now is far more precarious than it was before, and that's why I don't think that the answer for privacy will be in the market. And there's more burdens in consumers that sometimes have merged in this consumer/creator that are like actively giving input to actively interacting constantly with the new technologies and with the new platforms, giving, and receiving very little back. So, and with no safeguards and with a trust that is absolutely undermined.
Go ahead, Tanguy.
I'd like to raise one point, drawing a line, in fact, between the public and the private sector, because some of what has been said so far is very much in relation to the market defined as public sector, in my view. I'm not saying, of course, that there is no invasion by the private sector. That I think we have always to be careful. But I think nowadays, at least, the threat is coming from both sides. That's important to note. And the second point I wanted to make is education. Because there's one thing, when you drive a car, you're supposed to know how to drive a car. When you're on the internet, nobody tells you exactly what you have to do and what you shouldn't do. When you open an account, for instance, I won't name companies, but on a social media, it is absolutely crucial that, of course, you receive an information as to what are the consequences of what you're doing. But I think there's part also of education, and I'm especially thinking about children. Isn't there something to be done more than it is now? And I know that to some extent and in some instances there are some form of education, but isn't that something that governments should think more than regulating, that they should also educate?
So kind of following along in this vein, the free market economics assumes that consumers are making informed decisions. But has technology become so complex and so invasive, so ubiquitous, that data collection, that nobody really understands the data that's being collected about them? Is it realistic to assume that consumers can possibly understand these complexities in order to make informed and rational decisions in the free market regarding their data and privacy? Carolyne, did you want to respond to that?
I think well, that's always the easy answer. It depends.
Yeah.
No, I think, let's say, in general, consumers are not less able to understand, I think, what is going on with their data. For example, with the watch. I think with the watches that are now on the market, you can track your heartbeat rate, you can track your temperature, all your health data, which are sensitive data. And I think a consumer is well aware what happens with that data, and that in fact a processor or an entity or a computer somewhere needs to do something to get a report out of it. However, what a consumer, in my opinion, doesn't understand is how these data can be relevant to someone else. Typical example there is an insurance company. Of course, they would like to have that data because they immediately can recalculate the risk more accurately on that person. And there is a missing link. And I think it's not necessarily the consumer, it's partially the information that needs to be detailed, updated to give that long time perspective. And if that's not possible, then we need to find ways on the right to be forgotten. I think that's the situation, that if you cannot predict the future and give sufficient information in a notice, I think there should be a way that those data are not used anymore for that point of time in the future.
And again, it's really, really hard to enforce something like that if you have global markets with different levels of regulation, with different levels of compliance. But I want to refer to something else, and it's devices. Take, for example, your telephone. I mean, for a privacy authority or for a consumer protection office, it's really hard to know the impact of devices right now because of trade secret law, because of different levels of secrecy around a device that makes an audit practically inviable, or it requires like having like highly competent people to assess the device. And we have the problem of backdoors as well. So how can we even trust the market if the market is distorted by default by the secret deals between governments and companies who I am trusting the market. I'm buying I'm buying my laptop from a good company with reputation, with complying with law and so on. But the same laws that they are complying on the privacy side are laws. The same regime is forcing them to put backdoors. So I cannot even trust my devices anymore because I don't know at the end what's inside. Because the laws this company is subject to force this company in the fight against terrorism, in the fight against drugs and whatever, to deliver to the market something that is not. I mean, it is like I was drinking polluted water without knowing that I'm drinking polluted water. So I think that's a different angle from what we have learned from the Snowden revelations that hasn't been explored, and what will be like the response from the market to that pressure of secret deals to have all the security compromise for everyone, except I think it's a big issue.
Tanguy or Tal, did you have a response?
Well, I think this, again, is an example where there is a cross-border between public sector and private sector. I agree with what Renata has said about that, that the risk is there. The next question, I think, is what also Carolyne has said boils down again to the principles, because it's proportionality, it's the purpose definition, and how far you can go. The reuse by an insurance company of the data, your heartbeat or whatever, which has been recorded by a wearable, is supposed to be on the basis of an information, first of all, but also on a legal ground, at least in Europe. Then I would like to come back again to one of the statements I made in introduction. I think if those principles are common ground in all the regions in the world, then we could achieve something. My concern is that if we go too far in imposing rules that cannot be accepted by certain countries, we will never achieve it. So I come back to my second, I can't remember, point that I made during my presentation, is that we should have a regime which is efficient in the sense that it is realistic. And if it is realistic, it may become, I know it will take time, but it may become the standard of the future. So rather than, as my neighbor here told, said that it should be a strict regime that applies throughout the world, no, I think it should be not a lenient regime, don't tell that I've said that, but a realistic regime that can then apply throughout the world.
Thanks. Tal, did you have any comments, or should we move on?
Just make a very quick comment that might not be as intuitive. So it's very easy and probably true to say that because of the complexity of big data analysis, it's impossible to provide a notice and to a much greater extent consent, and therefore rolling the decision to the individuals is a problem. But the other end is can we roll this on to the government entities that will make decisions as to which practices are reasonable or within the defined purpose, that the practice is acceptable, that it shows promise in various realms. That's also a very problematic presumption, given economic forces, political forces, inadequacy, inability of government to reach these decisions. So we also always must be careful when saying that we need to take the power of decision out of the people and invest it in the arms of government without properly understanding the constraints these governmental entities suffer from as well.
Thank you. And I believe we have another question from the audience.
I want to respond to Tanguy's remark about the purpose limitation. And I think this is one of those concepts that sound really cool on paper. In practice, they don't work at all, because the challenge is that the companies define the purpose for themselves. They don't need to justify it to anyone. And that's why we see companies using ebook readers and track your reading patterns, because they think they should. They define the purpose. And that's why Angry Birds requires your location, because that's what they think the purpose is. And there's nobody telling them that, no, you shouldn't do that. And that's why we have all these millions of applications asking pretty much for everything.
Well, I think this is not true, at least in Europe, because the European system requires that you have a legal ground before you process. And as you may, sorry? Well, consent is one, but of course, if you're in an environment where you have an employment relationship, for instance, consent is not valid. So there are other ways to achieve the same result. One way is the legitimate interest. And you may have seen the work, which I think is remarkable, of the Working Party Article 29. They have made an assessment of the way companies should apply the legitimate interest. There's a 7-step process that needs to be applied. And frankly speaking, I think if you look at all these steps, it's very concrete, it's very practical, very pragmatic, and it works. So if you have done that, you must have a system where the purpose has been defined, is proper, is balanced with the rights of the individuals, and therefore, if you comply with this purpose, what I was talking about is the risk that, of course, the company does not comply and open the purpose to other things, but then it's a violation of the law. It's the violation also of the proportionality principle. So there are other principles that will come into play and that should create the boundaries for this.
These justifications on that make data processing legitimate, I think, are easy to bypass, as we see with all the applications. Like if you ever download an application on your mobile phone or a tablet, as we had seen earlier, then you will see you go through a consent screen. You have no choice other than accepting or not downloading the application at all. And that's why you can rarely find applications that will ask for very little data. They all ask for lots of stuff. And that's the same on the web as well, because there's nobody is basically asking these companies on, does this game really need to have access to your address book and your pictures? And because the company defines what the purpose is, and you will not be able to use it if you don't agree with those. And that's the consent phase. And then on top of the consent, you have, as a company, you have a couple of other choices on how you can basically bypass all these obligations and create exemptions. So it creates a false sense of privacy, which in reality, as we see today, isn't there.
Tanguy, did you want to briefly respond to that, and not because
yeah,
this
of course,
isn't a
I will make it very
dialogue,
clear.
but just
I think this is right, absolutely correct, but this would be then against the law, because then the consent is not freely given. So again, the law suffices, I think. The consent must be freely given, it must be informed, it must be specific, and it must be freely given. In the case you describe, there's an abuse of consent. Yes, did we need it 5 years ago when it was not existing? So that's more a sociological or philosophical question. I'm responding from a legal angle.
I'm just going to pass the floor to another audience member who's been waiting at the microphone.
Hello, Peter Craddock from Liederkerke in Brussels. I'd like to go back to the question of businesses and corporate social responsibility, and also the new initiatives in terms of rewarding, in terms of privacy enhancement. Because as Tanguy and Carolyne will know, the work of lawyers is basically a lot of education about privacy, because as both Tanguy and Carolyne mentioned, there's little awareness for many of the companies. And so I was wondering, in terms of those that you mentioned 4 categories. First one was those who are really embracing privacy and promoting it. Do you see some of those as being purely a fad, a way to attract attention, or are some of those actually honest and engaged in privacy enhancement?
Carolyne, did you want to respond?
Well, of those that I see, I think their true advantage is that they have the experience and practical experience. And by sharing that, and of course that's part of their program, is to share what they've done and how they've done it. And by sharing that, it makes it more tangible to peers, if I can say it that way. It also makes it more tangible to smaller entities, because the so what question often comes in SMEs, for example, who don't have the budget just to be, I mean, let's face it, they don't have the budget to start with a privacy program or to have a full mapping of their data. So if they see how it can be done, they can better make a step plan and you know, take the path to privacy. So I think that's their advantage.
Well, I would like to answer on this one, which I think is very interesting. In fact, when you look at a company nowadays is developing community investment, it is developing corporate social responsibility. You may question the honesty of all that, I agree. But on the other hand, it benefits to all. So the same thing applies, I think, for those who really, truly advocate in favor of privacy and develop programs that are covering privacy in full compliance with the legislation or in full compliance over their moral principle, because at the end it's also very important, the ethical rules, and there we come back to self-regulation. And I think the bottom line is the benefit for the citizens. If, thanks to that, they achieve more privacy and nevertheless do business in a decent manner, that's perfect for them, of course, and it's perfect for the citizens. So I think, yes, the answer is they achieve something.
Great, thank you. Just in the, Tal, did you have a quick comment? Or?
Very quickly,
Okay.
I'm not going to move into the intricacies of corporate law, but except for some exceptions, a company owes a duty to its shareholders to maximize revenue, not engage in various activities that are honest or dishonest. So if the company sees an ability, short run or long run, to increase its revenue, so it's going to set its business plan in a way that enables privacy. So it will all go back to the business interest. So I don't know if Mike wants to say something about this. Various shifts in different large company strategy regarding privacy. So the companies react to various market and also political forces, and the way they package it, saying they care or they don't care, I don't think is very interesting.
Okay, I'm just going to allow Renata just one quick comment. Yeah, no, and because we only have 15 minutes left and a lot of interesting questions, I'm sure, still to come, I'll just remind everyone of that. Thank you.
So, okay, last year, no, it was 2013, Brazilian government launched a provocation. The authorities saw that the market was not providing a means to really communicate in private using email. So they announced very loud that the state, because the market was not providing that, the state will provide state email service that was going to be secure and private and not compromised. So it was an interesting intervention from the state. They never deliver, of course, but it was a shift. You know, it was an interesting shift that freaked out some companies, and some companies start addressing the problem when they saw the threat of the state taking over their mailing services.
Thank you very much.
Just a quick follow-up question.
Quickly, please.
It was a bit about the privacy enhancing technologies, because one thing that we saw was over the past few years there have been a number of initiatives, such as back in the day of the beginning of Facebook there was Diaspora, recently there's been Lavabit and Silent Circle and so on. And it's mostly speculation at this point, but do you see these initiatives multiplying despite perhaps the lack of subsidies, but thanks to growing awareness, and then possibly down the line better privacy for everyone?
Are you directing that for Renata, or?
Mostly for Renata, but anyone else also
I
as
think
well.
that at least the region in the world that I come from, it needs subsidies, and it needs a vision of a country deciding to become the oasis of privacy and profiting out of it, being a safe jurisdiction with the best laws, with the best provisions that can offer what obviously US and Europe are not offering because of the backdoors and all the trust problems.
Thank you very much. Over to you.
If the chair will allow a brief intervention to follow up to that, and then my own point. The ELO Corporation is very interesting because they have created themselves as a public benefit corporation precisely to avoid what Tal said about the obligation to shareholders, and that's an interesting view that they've taken, that they're binding themselves and their corporate successors to a public benefit model, not a shareholder benefit model, precisely because they want to develop a privacy-friendly regime. But my own point was actually to Tanguy. I'm Andrew Adams from Meiji University in Tokyo, and I have to disagree solidly on you on the situation in Japan. Everybody in Japan that I'm talking to, privacy activists, people from government, and people from industry, say that the current Japanese data protection regulation system is broken. It's fundamentally broken. The privacy mark is useless. Nobody's ever had it taken away. Nobody in the public that we've spoken to understands what it means. Most of the people in the companies, actually, they've gone through it because it's there, and Japanese companies tend to be, we want to be compliant, but that's all that it's done. They've just gone through this process. It hasn't really changed what they've done. And certainly the idea of sectoral codes of conduct has not worked. And that's one of the discussions they're going through. They're going through a similar discussion to the EU at the moment about how to adapt and change the data protection regulations, because the existing one really, really just has not worked for anybody.
Did you want to respond?
Yes, I think I need to respond to that one. Well, I fundamentally disagree. Not that the law in Japan is not efficient, because I think to some extent it is true. But the privacy mark is an indication. I think we were talking about the honesty. Well, that's part of the honesty I think we can see in the Japanese companies. I've discussed with many of them, and they try to the best extent they can to be compliant. I'm talking about large companies, of course, small businesses. There's, like Carolyne has explained, the issue of awareness. Citizens, it's also an issue of awareness in Japan. This is true, by the way, in Europe as well. I think most people do not know about all this, but it's a matter of education. I don't think we can ask the private sector to be the educator of the world. I think it is a task for which we pay taxes to the governments, and they are supposed to do it. The privacy mark I was making the remark about is because it is embracing a large number of companies, and it shows that these companies have at least thought about privacy. And that's, well, you may question the quality of the system, but at least it has the benefit of existing.
Did any other panelists have any remarks? Or okay, Hans?
Hi, so Hans de Zwart, I'm with Bits of Freedom, a Dutch digital rights organization. I think that as long as we have the alleged duty to shareholders, or the doctrine that we call shareholder primacy, we really can't expect anything else from large multinational businesses other than to sort of exploit as much as possible the asymmetrical relationship that they have with their consumers in such a way, I mean, similar to, I don't know, the slot machine business or something, where you want to actually pull as much out of your customer, or in that business actually called your resource, as possible, without them sort of collapsing and not being able to continue to play. But what I am starting to notice now is sort of more and more companies doing something that I'd like to call privacy washing, which is the selling your products with some sort of privacy byline. For some reason, it's not me, but for some reason, whenever I mention that word, people look at me and say, Microsoft? But I, I don't know why. But what I mostly see is that, similarly to Shell, which investment in green energy completely consists of PR budget and marketing budget, I think that might be the same for some large information companies here. What I'm wondering, though, is sort of one sort of small opportunity that I see is the fact that in the end, these large software and information monopolies, they really do not have the interest of the consumer at heart, which also means that they make choices that are actually not beneficial to me. So I'm starting to notice this more and more whenever I use Google. In the past, Google is actually sort of a pleasurable experience for me. And more I start to notice that they're doing things where I see, hey, this is good for Google, but maybe less good for me as a consumer. And as software is a less capital-intensive business than oil, so to say, I think there is actually an opportunity for software that does respect the user's rights, which can actually be as good. You know, there's no reason why there's not an email client that works as well as Gmail in this world that does respect my human rights. So do you also see that as an opportunity or as a gap that might grow larger and move towards a solution? That's my very long question.
Thank you, Hans, for that very long and provocative question. Before I invite the panel to comment on that, I'm just going to do something unconventional and pass the mic over to the chair for a moment.
I know a little something about Microsoft. You know, companies are for-profit companies, and there is a reality that the primary objective is to drive revenue. Having said that, you know, I think I have seen within at least the company that I've worked for a number of years, it's not just, I mean, there are ethics and there are the right thing to do, and I think people genuinely make decisions based on that. And I think when things come together, and they don't always, but when they come together and people feel like within a company that it's the right thing to do, and there's a business benefit to do that, then you see good practices emerge. And you know, you mentioned email. You know, Microsoft has taken a position that we will take a hands-off position with respect to the content of email and not use that for advertising purposes. Now, of course, content is scanned automatically to prevent spam and to index it so you can do that, but we've made decisions about leaving money on the table, leaving advertising revenue on the table, because we think there's a bigger business benefit to being able to tout the privacy benefits of that will offset that practice that we're declining to engage in.
So not ethics, but the value to the customer is now suddenly higher. It's like how Google suddenly turned on HTTPS for everywhere, which they could have done years ago, but wasn't worth the investment until there was enough sort of customer demand for it. So it's not being cynical, it's just the reality. But you should not ignore that reality and work towards an alternative if we really care about human rights.
Thank you. Carolyne, did you want to start? Okay, let's do a round, and then I think we should be nearing.
Okay. Just one short comment on that. I think indeed it will depend on customer forces, if I can say it this way. On the other hand, I don't think that companies and users are having completely different discussions. If you talk about privacy is usually, you know, consumer oriented or user oriented. So it's to protect the civilians and the users, but it is data, and data is of value to a company. And of course, if it's not what they do, that's not necessarily directed to the consumers, but it is an asset. It's like intellectual property, and I think companies are well aware that they need to do something with that data. It's usually security, but that's at least the first step towards privacy. So I'm not sure that it's two different discussions, if you see what I mean. I think there's some common ground between stakeholder interests and user interests. It's just, putting them on the same paper.
Thank you, Carolyne.
Well, I will make a metaphor. I think we are no longer in an old Western where there is the good cowboys and the bad Indians. I think it's more complex than that. It's a combination of factors. Thank you. Thank you. It's a combination of factors. Companies, at least those I advise, are genuinely trying to be compliant. They are in a tough world because they have competition. They must make profit. All that is true. And I think part of the answer is there, but the other part of the answer is with the users themselves, with the consumers themselves. And part of what they can do is get better educated. And I come back to my public sector duty, which is to provide this information also. So I don't think we will ever have one single answer by just promoting that there is no shareholder anymore and that the private sector is only working in cooperative. That is not going to be true. And we have to combine things. Nothing of what has been said today is wrong or completely true. I think it's a combination of factors.
I know that some audience members want to respond to that, but just to give the panel an opportunity just to make some final comments, perhaps I'll invite you to follow up after the panel, your conversation. Sorry. Tal?
Thank you. I'll just build upon the comments of my fellow panel members. So we mentioned the need to regulate in a monopolistic environment. So first of all, in many of the instances, as mentioned, the companies do not operate in a monopoly. And even when you have one dominant player, you must remember that there's a fear that if you don't comply with market needs, you're just going to build into another competitor, a virtual competitor that will come up into play. So you have to be very careful when you're saying this firm is a monopoly, we need to regulate it, especially in these ICT realms, also in the context of privacy. Another point is we talked about responses by firms to what the customer wants, what the consumer wants, but also even for a monopoly, there is a response to what you're afraid the government might do. So in the Brazilian story, I like this, the point that I'm not sure that the firms were very worried about the competition they'll get from a Brazilian email system, all due respect, but they thought this is a very strong signal that the government will be much more aggressive given its the fact that it's willing to put up so much money. And this was a very strong signal of future regulation, and then the firm becomes more protective. Now, my last point is, what do we actually make of actions of firms that they become more privacy friendly? So there's been a lot of work about Facebook and the additional options that it provides, and empirical data show that the more options you provide individuals, the more information they end up providing, and there are various explanations for this correlation because people perhaps feel empowered. So what do you do with this piece of information? Do you say this was Facebook's plan all the time? And they enjoy all the worlds. They tell one part of the world, we're giving you more privacy options. The other part of the world, there are customers for the advertisements who say, here, we did this to get more personal information. So it's very tricky to figure this out. Even when a company becomes more privacy compliant, maybe it has various motivations. Perhaps some of them are being possible to convince people to give additional information. But my last point would be, maybe that's what the people want to really do. And any other point regarding that issue would be paternalism by the state. So this is a very tricky issue.
Thank you so much, Tal. And Renata, the final word.
Oh, good. Well, I was really, really glad that you raised the issue because, I mean, we are in we are talking about here about free market, ideal market, but the truth is that here in Brussels and in Washington, these companies who are profiting the most out of this total broken privacy system, they have lots of lobbyists pushing for their points in European Parliament in Washington. And on the other hand, what is left to us? I mean, we don't have the same leverage that they have, or the money, or the resources, or even the data that they have, even about us. And so this privacy protection shouldn't be left to the market, but the market, local markets, emerging local markets can be, it might be part of the solution, you know, but we need to involve local politicians and local, the new generation of business models in different countries, outside, maybe outside EU and outside US, to start exploring the issue. A new ethic of business is necessary, as it was with the environmental issues. I think that if we look at certain jurisdictions who can be the leads, maybe not to deliver like the full global market, but at least for local, having solutions, for example, for local governments to have. I mean, I am terrified about the fact that all Latin American countries are running in platforms that are full of backdoors, you know, and that my national security is compromised because of preserving the national security of someone else, and there's a market there. No one, I mean, but for that, we cannot depend on precarious projects. I mean, underfunded with crowdfund donations and budgets that are not even 10 million. We need to think bigger solutions. I think that if politicians, I leave it to politics and political demand. If citizens start demanding it, the governments will see the opportunity and allocate resources to fund it, because it cannot be subsidized by the users at this point, because we have to catch up with so much.
Thank you, and thanks to all the panelists. I've enjoyed this lively discussion, and thanks so much to the audience for making it a lively discussion. All right, coffee time.